Good morning, Remax Distinctive Agents. It's Dan Bouchard Fernandez with the DC required training update. Today's discussion is a discussion on the Code of Ethics of Washington, D.C. It is enshrined into law, and it is not the NAR Code of Ethics. It is very similar to the NAR Code of Ethics in some ways, but it is not the NAR Code of Ethics, and we're going to dive right into it. The link at the top of the page right now is a link to where you can find the Code of Ethics. So if you go ahead and go to that link, you'll find it. You'll scroll down to the item number that says 172609, Code of Ethics for Real Estate Brokers, Real Estate Salespersons, and Property Managers. And the text of it is going to be found in the right-hand side in the View Text field. So that's where we are. This is what the document looks like, and let's go ahead and start covering a couple of items on it. A licensee shall not discriminate or assist any party in discriminating in the sale, rental, leasing, exchange, or transfer of property to any person or group or persons because of any of the protected classes in Washington, D.C. This document was created in 1977. And of course, since then, we've had a lot of updates to the protected classes. So currently there are 21 protected classes in DC that we look forward to. All right, I'm not going to spend a whole lot of time on that because we all know that we can't do anything to jeopardize our licenses that way. So the next item is going to be a licensee who has information that would lead a reasonable person to believe that a real estate broker, real estate salesperson, or property manager has engaged in fraud, misrepresentation, or unethical practices shall, and I repeat that shall, promptly report the information to the real estate board in any investigation or proceeding concerning any conduct prohibited by the act. We have an actual obligation to report fraud, misrepresentation, or unethical practices by any licensees. A real estate broker shall not advertise without disclosing the broker's name, the telephone number, or the company's name, and the telephone number or the company's name and telephone number. So in our case, it would be the company's name and the telephone number for any of our offices will work. But you must use the brokerage's full name, Remax Distinctive, and you must use one of the local phone numbers that is affiliated with our brokerage so that any consumer can reach the supervising broker, myself, and or reach our owner, Andrew Reamer. All right. Next topic is an obligation to advertise only while disclosing the broker's name and telephone. We all know some of this, so bear with me as we cover some of it, and we're going to just be aware that these are a matter of law, not just a matter of code of ethics, if they are similarly attached to the NAR Code of Ethics. A real estate salesperson or associate broker shall not knowingly permit the use of his or her name in any advertisements without the name of the brokerage company with whom he or she is affiliated and the main telephone number of the brokerage company or branch office which serves his or her regular place of employment. So if your owners of your listings are doing independent advertising, they must go ahead and include the brokerage's name in their advertising and the phone number, and they may go ahead and attach your contact information as well, but that must at least have the brokerage's name and listed by Remax Distinctive and the phone number. So let's go ahead and make sure that we're in compliance with that so we don't get held and charged with any violations of the law in this respect. Licensees must not allow others to advertise using their names without subsequently identifying the brokerage phone number. There is no saying, I didn't know, so and so was advertising this way. The licensee is ultimately liable. So if your seller's doing it, it's your obligation to know what your seller is doing in conjunction with the listing, and the responsibility for any advertising that they're doing needs to comply with the law, and you are responsible for it. And the law doesn't look at, I didn't know that they were doing this as an excuse. So just be aware, this is an effort to educate you so that you're not going to be caught off guard and you're prepared for getting answers to the Real Estate Commission if they do flag you for any kind of issue. A licensee shall make a reasonable effort to ensure that all written agreements for the sale, purchase, rental, lease, exchange of real property set forth the exact agreement of the parties, and the copies of the agreements are made available to each party when the party signs the agreement. So immediately upon the agreements that you're signing, whether it's your buyer agency agreements, your listing agreements, your tenant agency agreements, or the sales or lease documents, those parties must receive a copy of that as soon as it gets signed by them, and then also as soon as it gets ratified and signed by me as the supervising broker. So make sure that they get copies of those immediately, and not to have any delay. A representation agreement does not have any binding effect unless it is co-signed by the broker, and any actions that you take in your listings are deemed to be illegal acts. If you are operating as a listing agent and it hasn't been co-signed by the broker, your acts in that listing, doing your acts in conjunction with that listing, are illegal acts if it's not been signed by the broker. So don't get caught in that situation. We can't post date a listing agreement or a buyer agency agreement after the fact. We have to do it at the time that it's executed. So let's make sure that we get our paperwork in together and stay out of trouble that way. An obligation to ensure that all written agreements are complete and accurate, and that the parties actually receive their copies at the time of signature. A licensee shall not prepare or be a party to the preparation of any written agreement for sale, purchase, rental, lease, or exchange or real property that falsely recites the purchase price. So false considerations, anything under the table, it has to appear, it has to be documented in the documents, and it has to appear on the settlement statement or in the lease. So we can't make any underhanded comment, any underhanded prices or wink, wink, this is going to be money under the table. That can't be done. I know that we all know this, but it's good to have a reminder sometimes. So this is what we were obligated to follow. No party to false considerations, and a licensee shall make a reasonable effort to ascertain all material facts concerning each property for which an agency is accepted. So we take a listing agreement, and you see that there is a water stain in the ceiling, and you decide to simply ignore that water stain and not ask any questions about it, not not try to discover why that stain might be there, what has been done to stop that leak in the ceiling. You don't exercise your due diligent efforts to discover why the evidence is there clearly in front of you. Then you could be held in violation of this article of the Code of Ethics of DC, which is actually statutory law. So let's make sure that we understand that. It's our due diligent effort to discover material facts about the property, just using that as one example. Licensee shall make a reasonable effort to keep informed about the laws and rules and governmental policies and current market conditions in order to be advised of to advise the client properly. So this means that we have an obligation to remain informed about the policies and market conditions and laws. And the excuse that I didn't know that this law was an issue doesn't hold any weight with the Real Estate Commission. They don't care that you don't know. They just want you to be informed. And so our obligation as licensees is that we stay informed. And so these training classes that we're holding is an effort to keep you informed about things like that. All right, licensee shall exercise fidelity and good faith to a client in all matters within the scope of the licensee's employment. The obligation of fidelity to the client's interest does not relieve the licensee from any statutory or regulatory obligations. So if our clients tell us to do something illegal, we know that we can't do that. The law always preempts anything that's written into any code of ethics or anything else like that. So the law always preempts anything else. So if our sellers or our buyers tell us to do something illegal, we know that we can't do that, and we must contact our supervising broker to discuss it and to figure out the next steps. All right. If my loyalty to my client requires me to break a law or regulation, what must I do? Contact me or Andrew. A licensee shall not accept compensation from more than one party to a transaction without the full knowledge and consent of the other party or parties. This becomes a new issue now with the new class action lawsuit settlements that have come into place. And because there's now a possibility that you could be receiving compensation from multiple parties. Maybe part of the commission comes from the buyer, maybe part of it comes from the seller, or other formulas like that. We need to make sure that everything is written in and documented in the sales contract, and that nothing is done by oral communication. It's always documented, and consent is signed by the parties. I'm not going to go into a lot of the detail on this stuff. This stuff is taken from a course that I teach for GCAR, but it's important for you all to know this. A licensee shall disclose in writing to all parties of the real estate transaction any ownership or financial interest. So if you are an LLC owner or a co-owner, or you are a family member of any real estate that you're listing for sale, or that you may be a family member of a purchaser, or as an LLC purchaser as well. Any kind of connected financial interest, we've got to always disclose it. All right. And finally, a licensee who manages property on behalf of the owner of the property shall not accept any commission or rebate, profit, or other valuable consideration on expenditures. So if you're going to add a finder's fee on top of your contractor that you're having do work for the seller on the property, add maybe 10% on it, or 15, or whatever that number is. You can't do that unless you've got written consent from that seller. This Code of Ethics continues on. There are more sections to it. This just covers the basics of it. Please refer to the text and the link at the top of the page, and we will see you later at the next training in a month from now. Have a great day. Bye.